on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was
All right,
supposed to start in August.
ma'am, here's the problem. Problem is your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense for me, but it makes sense from the attorney? You're being biased.
I'm done. You're not
You're
going to
biased.
interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very biased.
Written issue. Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and you're very biased. You need to do your job. You don't know how to do your job. That's all.
I am done.
And Your Honor, I don't anticipate there being anybody present on this matter. Your Honor,
Okay.
This is plaintiff's motion to demolish a manufactured home. As indicated in the motion, this is for non-payment of rent. We took a default judgment, I believe, in June of 2025. That judgment has not been paid. Home remains on site. Nothing's been paid. Post-judgment, no attempts have been made to remove the home from the site. So in light of those reasons, as well as the additional reasons stated in our motion, we request entry of an order allowing for the home to be demolished.
And hearing no objection, the court will grant that. And I've signed the order that has been presented to the court. All right.
Thank you.
Thank you. Northville Crossing versus Rebecca White. This is a motion for entry of an order for issuance of the order of eviction.
It is, Your Honor. In this particular case, we're beyond 56 days. Your Honor, no monies have been paid towards the judgment amount. And currently, including the December charges, we are at a balance of $6,879.93. So for those reasons, we are asking for issuance of an order of eviction.
Again, hearing no objection, ordered, and I've signed the order granting that. That was presented. I don't think there was not a.
I don't know if we.
Yeah, I don't have the red, but
okay, we'll get that submitted. Okay. If it hasn't, or I don't think the civil division would hold on to it. It'd be in the file, so we'll go ahead and get a writ filed into the court.
Great, thank you. In Arbor Woods versus Kiera Morris. Kiera Morris. This is her motion to set aside default.
It is indeed, and we did file.
I'm here, Judge. I'm sorry, I couldn't get my phone on to work.
All right, it's her. Oh, there you are. Hello, state your name.
Kiera Morris.
All right. This is your request to set aside the default?
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing?
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay, have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay, I took a judgment, or a judgment was taken for in November for
Mhm.
1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arborwood's paperwork, they still had down that I had a balance. So we still should have been in court. So that is, um, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Dornbush?
well,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time to. I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My
Well,
rent was supposed to go
first
up
of all,
in
first of
August.
all,
I'm sorry.
there was and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush. There was so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3 hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms.
That's
Morris was
absolutely not true.
100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file two motions. So I don't know if both of them actually had came through. I can pull up the ones that I have and I can send it back into the
Ma'am,
court.
ma'am,
So,
I have your signature
mhm.
on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the.
This hearing quickly turns heated as a tenant argues that her rent records are completely inaccurate. She claims her landlord repeatedly changed the numbers, charged the wrong rent amount, added late fees incorrectly, and even applied fees before her lease officially began. According to her, these errors go back months and were never properly corrected. The judge repeatedly asks one simple question: where exactly is the math showing a discrepancy of over $1,300? Despite a very long explanation, the tenant struggles to clearly connect the numbers in her motion to the amount she claims is wrong. The court becomes frustrated, noting that none of these detailed arguments appear in the written motion that was filed. As emotions rise, the tenant accuses the judge of bias.
Default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that, because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
And I'm
and it did
confused
not
on the
get filed.
motion.
It
Go
did
ahead.
not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I do.
So,
I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they need to train staff, and we're trying to come to a resolve. So my information hasn't changed, and my issue hasn't changed either. And if we would have been in court in May, because that ledger says
well,
that I
in
had a
May,
balance.
ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct, the same
So,
day, Judge. Ms. Dornbush is not
but
acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with
when
her.
are you saying that happened?
That happened on the same day, on 5/6 of
Do
2025.
you see that on the account, Ms.
I
Dornbush?
am, I do see that, Your Honor, and I believe, I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to
Right.
pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June. Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made. I
Well,
mean,
sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it, and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed, because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand that
what is her
they didn't.
current balance?
The current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in
I know
September.
that.
Okay,
So
I'm saying in
you tell
September.
me,
Yeah.
taking out all of that, how
Mhm.
much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was owed was
Did you pay
$360.06.
December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as
Okay,
well.
I got 700. So you're
My
saying that if I take that 700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your
You
Honor.
can say
Where
absolutely not
where
if you
is
look at
that
the
gonna
first.
come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024
All
to.
right, so in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you two late fees per month.
Okay,
So
so
that's
even if they did
$85 per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is 55 that gets charged on after the 5th, and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Miss Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at to July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen
If
to
you
me.
look on my
Listen
ledger.
to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm
Yes,
asking
sir.
you for where that discrepancy is.
Okay,
You
sir,
are
and
giving me
I'm
150. I'm not
sir.
agreeing with you. I'm just saying,
Mhm.
where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. August, I go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out she sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You
Okay,
have
so let me
given
rephrase
me
this,
a
Judge.
total amount of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually put it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow in November. My rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was supposed to start in August.
Ma'am, here's the problem. Problem is your motion says none of this.
Is that my motion a motion that I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense for me, but it makes sense from the attorney? You're being biased.
I'm done. You're not going to interrupt.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very biased.
May issue. Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and you're very biased. You need to do your job. You don't know how to do your job.
That's all. I am done. Motion denied.
Your Honor, I would request that the monies held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney. You have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her out of the meeting. Court does call the case of Arbor Woods versus Lakeisha Sanders. Lakeisha Sanders, not here. And this is non-payment. Yes, if you raise your right, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Palad's Law, on behalf of the plaintiff. Your Honor, rent retained is $3,400. I think it's a $62.66. Costs are $186 for a total due of $3,648.66. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with writ issue in 10 days. Arbor Woods versus April Tubbs Streeter. Not checked in.
Correct, but there should be a second.
Oh, and that's right. And Elise Streeter. They are not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $636.79. Costs are $242 for a total of $878.79. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. All right. I think that does it.
I think it does
Okay.
indeed. It's good to see you guys.
Yes, ma'am. And you. And the
Thank you.
family's doing well, I hope.
We are doing very well, and in fact, you just missed the little one. My mom was putting my 2-year-old down for a nap, so the baby was in here with me, and she came and got him right before you started the Zoom session. So you
darn.
just missed him. He might have been screaming his head off, which
That's
not
okay. I like that.
I said to my mom, I said, Judge Simpson's probably the only judge in the state that wouldn't give me crap for having the baby in the room with me while I was in court.
Exactly. I'm upset by it now.
Now,
Right.
actually, there's one other judge that I think would probably be okay with it. Judge Andary in the Romeo court. I spent time there on Wednesday.
And repeatedly interrupts. At that point, the judge firmly ends the discussion, explains that courtroom rules must be followed, and denies the motion outright. The escrowed funds are ordered to be released and applied to the account balance, and the tenant is removed from the hearing after continued outbursts. The court then moves rapidly through several other housing cases. With no tenants present to object, multiple default judgments are entered for non-payment of rent. In one case, the court even authorizes the demolition of a manufactured home after a long-standing judgment remains unpaid. This hearing highlights a hard truth of civil court. No matter how emotional or complex a dispute may feel, the court relies on clear paperwork, accurate motions, and precise numbers. When those don't line up, even a long explanation may not be enough to change the outcome. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next one.